versus the state. Benjamin Sessions for appellant, Michelle Disman for appellee.
All right, I forget what we do next. You may begin if you're ready.
Cool to follow that. So, this case, Ms. Walker's case, had been pending for approximately 29 months before her bench trial came up to be heard by the court. During the intervening 29 months, approximately 13 months was spent on a dead docket. The state had moved a dead docket the case, and it sat dormant for that period of time. At some point in time, she waives jury trial. The case is noticed for a bench trial. Approximately 42 days elapsed in between the date that she waives jury trial and the date that the bench trial is scheduled for. During the intervening time, there is no motion for continuance, no notice as given to the court, no notice as given to me, that the state was in fact going to be unprepared to move forward on the scheduled trial date. There was no motion to null pros the case. The state could have moved under 17-3-3 to null pros the case and thereby received, if the court were to grant it, an additional 6 months to prepare the case and to reinitiate it during that period of time. They elected not to do that. On the scheduled bench trial date, the state had no witnesses that were there and present in court. There was no arresting officer. There was no phlebotomist. There was no toxicologist from the crime lab. There was no witness in support of their case whatsoever. And the trial judge said, "State, I'd like for you to go out in the hall and try to figure out why it is that you don't have witnesses here. Where are your witnesses?" And the only explanation that was given was that our officers are on leave. So that we came back into court, and the judge did what I believe almost every judge would do in that situation. With no explanation before them, she made a very rational decision, which was that she's going to dismiss the case for warrant of prosecution. That dismissal for warrant of prosecution occurs outside the applicable statute of limitations for a misdemeanor DUI. No question as to that. I don't think there's any question that I do believe the statute of limitations bars the prosecution or the reaccusation of this case later on.
Can I ask you, so the court dismisses for warrant of prosecution. Where does that process come from?
It comes from this court's decision in Remy, the 2020.
I wrote Remy, and we just cited it's dicta, and I cited Court of Appeals opinion. And when I've looked at it, the first mention in a criminal case of dismissing for warrant of prosecution seems to be in the 1970s in a case that says you can't do that if you dismiss with prejudice. And then the next case from the Court of Appeals says, well, they didn't do it with prejudice, so I guess it's okay, which is a pretty weak basis to say that it's okay. What about for the first 200 years of this court's history? Was there such a thing?
Judge, I'm not sure. I truly do not know the answer to that. I know that it is, we've interchangeably begun using the term with and without prejudice in our criminal cases. Obviously, there is no corollary to 9-11-41 in our criminal procedure. And unfortunately, our trial courts routinely use the term DWOP, or dismissal for warrant of prosecution, or dismissal without prejudice.
Well, here included neither.
Yes, sir, that's correct. That's correct, Your Honor. It says dismissal for warrant of prosecution, I believe, under this court's precedent in Price, Martin and Sons versus City of Leesburg, those cases that you would have to presume the validity of that order unless we showed something to the contrary.
Well, let me ask you, counsel, the inability to retry the case or re-indict the case, if so be, is not a product of the dismissal. It's a product of the statute of limitations, is it not?
That's correct, Your Honor. And if you were to apply any ruling that a trial court makes in the course of presiding over a case, conceivably, quote unquote, interferes with the ability of the state to prosecute its case. All rulings that a trial court makes have some influence and shape the case. So whenever the state they use the language from your case in Remy and also from Kelly, where it talks about impermissibly interfering with the right of the state to prosecute a case. Well, all rulings that a trial judge makes in the course of ruling upon which evidence, if, for example, a trial judge were to set a timeline for the production of a witness list and excludes a witness on that basis, that might very well interfere with the state's ability to.
Well, that's Banks. So let's talk about Banks for a minute. So Banks, the case that it appears the Court of Appeals predominantly relied upon for the proposition that we know that courts cannot dismiss with prejudice criminal cases. And we're implying that this is a dismissal with prejudice, notwithstanding that the order did not say that it was with prejudice. But the Court of Appeals isn't relying on Banks. Banks is different, right? Banks' issue in that case, as I recall, and there was no cert in that case, so we haven't had a chance to weigh in on Banks. But in that case, as I recall, the issue was whether or not it was appropriate for the trial court to dismiss a case for a discovery violation. This was pre-trial, of course, and the case was dismissed for a discovery violation, and the whole issue that came up was whether that was even a permissible sanction, correct?
Your Honor, Banks is completely opposite of what we have here. We are set for trial on this date. Banks was a calendar call where a judge en masse dismisses a whole slew of cases there. There was no opportunity for the state to come forward and produce evidence as at a trial setting.
I mean, I think factually that's right. But isn't the thread that is similar between the two the question of whether a dismissal functions as a dismissal without prejudice? Or with prejudice, pardon me.
I'm not sure where it is that we're getting the functions as a dismissal. Let's say
Well, I mean, Banks, right?
So Banks says that, but I'm not sure where Banks gets that functions as a dismissal, how the application of other law then converts an otherwise proper dismissal for want of prosecution to a dismissal with prejudice.
Well,
That's
to go
the
back to
additional
my
link.
part of the problem is, where do you get to dismiss for want of prosecution in the first place? That when you dismiss a case, whether with prejudice or without prejudice, the court is killing the case, right? It takes it back to a position when there's a dismissal, the state has to restart the case with a new accusation or indictment. And we have generally said that that is a very disfavored remedy unless there's a legal basis for it. When I go back and look at the case law, the legal basis seems to be a case which, after 200 years of not doing this, seemingly it is a process in civil cases, right?
It is.
Said you can't do it with prejudice, and then the next case says, well, this case isn't without prejudice, it isn't with prejudice, therefore it's okay, and then it's kind of off to the races, and our court has only referred to it in dicta.
Correct, in Kelly and in Remy as well. Remy arguably is a substantive ruling upon that, not in dicta.
Was there a dismissal in Remy for want of prosecution? I mean, no.
Correct. Yes, sir. I stand corrected on that, Your Honor. I apologize.
So, again, I mean, you laid out at the beginning of your argument a number of things courts are clearly authorized to do. They can call the case, and if the state doesn't put on evidence, they can direct a verdict of acquittal. We've said that's a process. They can put it on the dead docket. They can null process. But where do courts get the authority to tell the state your prosecution is dismissed because you didn't show up?
So one of the primary arguments that the state makes in its brief is that we should apply form over substance. I completely agree with this general proposition. They cite State versus Fly for that proposition. State versus Fly dealt with a case. It's exactly what we have here. It's different terminology that's used by the trial court, but nonetheless, it is exactly the process that we had. In State versus Fly, you had a defendant who appeared on a scheduled trial date. The state produced no witnesses in their favor, and the court granted a judgment of acquittal under those set of circumstances. The issue was joined in our case. We also had a waiver of formal arraignment, just like the defendant did in Fly. We also appeared on a trial date, and we have a judge who, although using different terminology, is the exact same procedure.
Except the court did not enter a judgment of acquittal. The court entered a dismissal. Those are not the same thing. A judgment of acquittal is a judgment on the merits. A dismissal is a dismissal, but I'm still trying to figure out on what legal ground.
But, Your Honor, it has the same practical effect. If we are to apply this idea of the form doesn't control over the substance of what actually occurred there.
Same practical effect. Just let me ask, a judgment of acquittal is double jeopardy. A dismissal is not double jeopardy. That's a pretty big difference in effect, right?
I'm not sure if jeopardy even attaches in that judgment of acquittal with no witnesses being sworn in State versus Fly.
It can't be a judgment of acquittal if there's no jeopardy.
That was what was the process that the Court of Appeals recognized in State versus Fly as an acquittal.
Counsel, can a judge dismiss a criminal prosecution based on a contempt by the state?
No, sir, I do not believe so.
Even without prejudice?
No, sir, I do. It's a confusing body of law that's developed in the Court of Appeals for sure. I do believe if they could reaccuse the case within the statute of limitations, it is possible that they could do that. But if you have contempt of the state, for example, is probably not a proper legal basis that the court references in Remy and in Kelly as a basis for a dismissal for warrant of prosecution.
So other than want of prosecution, what are the bases for a trial judge to dismiss with or without prejudice? I mean, I know we're talking about not without, but without prejudice, a criminal prosecution.
I believe that is, for the most part, that's the avenue that I've seen that it would arise.
No, there are 10 other ways, right? The indictment is defective on its face. The indictment is defective in substance. I mean, there's a whole bunch of different ways that you can dismiss a criminal indictment for a violation of the law, right?
Sure. If you have a demurrable issue, a generally demurrable issue, right, then yeah, but it typically is called just a demur being granted in connection with a motion to dismiss.
Does that ordinarily prohibit the retrial of that case if it's still within the statute of limitations?
No, sir, it would not. The court was referring to the Banks decision. I believe if we look at Banks in the cases that it relies upon, Banks is not good law for us. It cites to basically 3 different cases that it relies upon. Luttrell, it also cites to Grimes. Grimes is the case that's most analogous to our case, but Grimes only refers to the statute of limitations and dicta as well. It is not factually aligned with us in that basis. It's the additional step of saying if a judge is otherwise appropriately granting a motion to dismiss for warrant of prosecution, can you then renew it? And it says, yes, in Grimes, they were within the statute of limitations, so they could have brought it back there.
What's the proper standard of review for a dismissal without prejudice?
I believe it's de novo.
It's a de novo review of the dismissal.
I believe so.
What is it?
I believe in our case it is.
Then,
I'm sorry.
I mean, what is the standard? I mean, what is it we're reviewing de novo? What's the legal standard for whether you can grant such a dismissal?
First, in this case, I believe that we're just looking at, does the law prohibit the statute? Does the law, based upon the application
apart from the with versus without prejudice issue, what else would we review? What is the trial court supposed to be making a decision based on?
Did the judge exercise sound discretion?
So that would be abuse of discretion, right?
Correct. In the normal motion to dismiss for warrant of prosecution, the appeal that would flow from that, did the judge have an adequate factual basis? So to the extent that we're concerned about, I've never had this experience, but if you were concerned about trial judges just sort of freewheeling, giving out dismissals for warrant of prosecution, that has not been my experience at all in the trial courts throughout the state of Georgia. I do not encounter judges who frequently give away dismissals for warrant of prosecution.
What would be the outer limits of what you consider a proper dismissal for warrant of prosecution? At arraignment or at a motion to suppress stage, or do you have to call it for trial? I mean, and how do you draw that line?
That's a great question. I do not believe that you can dismiss a case for warrant of prosecution properly in a trial court until there is a trial setting.
Well, then what's your authority for that?
That's all those cases that are cited in Kelly, Bakken, and Santiago were exactly that scenario, where you had a pretrial hearing or a pretrial motion hearing or some sort of pretrial calendar where a judge either interferes in plea negotiations or dismisses a case at
Did those cases rely on any particular legal authority in sort of articulating those standards, or is that just sort of the law that has evolved through those decisions?
I believe that is the law that has evolved through those decisions, Your Honor. That is the one distinction I do see here in this line of cases, is that whenever a trial judge steps in at the pretrial setting to dismiss a case for want of prosecution, that typically is going to be an improper dismissal for want of prosecution.
That would be an abuse of their discretion to grant to grant the dismissal.
I believe it would be, Your Honor.
Even if it was without prejudice?
There is a case where a judge said, he uses the phrase, I'm going to give the defendant a chance to straighten it out. He used that phrase I believe it was a restitution type issue in a case. And that dismissal, he said, I'm going to dismiss this case for want of prosecution in order to give the defendant a chance to straighten it out, something to that effect. That dismissal's made within the statute of limitations. That was approved of by the Court of Appeals.
Okay.
I don't believe that that's proper.
So we got
but
to
nonetheless,
overrule that one too.
Your Honor, if it's within the statute of
I'm
limitations.
trying to figure out if this is just made up stuff with no firm legal basis, but you want us to overrule it on the ground that what? We want to make it up a different way? Or do you have, what is the core that we're actually, where is the legal authority of a trial court to dismiss a criminal case because the prosecutor hasn't done something?
If this court finds that a dismissal for want of prosecution, a trial court has the authority to do that, which we previously.
Is there a legal standard articulated in a statute somewhere for what a prosecutor has to do to avoid having their prosecution be found wanting? Is there a legal standard in a statute for that?
Well, you need to come forward with a witness, but I'm not sure that that is articulated in a statute.
You don't have to. A prosecutor can start a case without telling the court whether the witnesses are there, right?
Correct, Your Honor. Yes, sir.
So that can't be the standard. You have to show up with a witness and tell the court before trial, I've got my witnesses here?
Well, whenever the court says, are you ready to move forward, and the state announces, no, Judge, we are not ready to move forward because we don't have witnesses here, well, then we know dispositively that.
What if they don't have exhibits they need?
That is, if they choose not to go forward in the face of a trial judge's, a trial court's ruling, that we are moving forward with this trial.
So is the key then less they don't have a witness or they don't have an exhibit? The key in your position would be the state says they're not prepared to move forward?
That's correct. Yes.
And so whatever forms the basis of the lack of ability to move forward is sort of beside the point. The state has announced
Well, and then if it's that theory, then if that had happened in this case 6 months earlier, we wouldn't be here today, right?
I'm sorry, Your Honor.
Well, so Justice Peterson is saying if it was asking you if what you were articulating was a standard as a rule of if the state says that it's not ready to go forward, then that is what triggers a permissible dismissal for want of prosecution. And then what I'm saying is if that's the rule, then in this case, had that happened 6 months earlier, that the judge had said, we're ready to go, are you ready, state? And state said, we're not ready yet, we don't have our witness. Had that happened 6 months earlier, we wouldn't be here today because of the operation of the statute of limitations.
As long as they renew it within the applicable statute of limitations.
Sure, but I guess my point is if that's going to be the standard that we judge by, then it really depends on when the state says it's not ready to move forward, and that seems like a moving standard as well and poses its own set of problems.
I do believe that the state is under an obligation to exercise a heightened level of diligence once the statute of limitations expires. That is what I believe the practical effect, if I'm correct on this proposition, will be, is that once you have a statute of limitations that expires, the state had better know whether or not their witnesses.
Wouldn't it also, under that theory, wouldn't it also matter to exercise that discretion when you're close to having the statute of limitations expiring too?
The state absolutely should. If it matters, then you need to know whether or not your case is going to be prepared.
Do we need this rule? I mean, if the state shows up and says we're not prepared to go forward, again, you can ask for continuance, the court can call the case, the court can put it on the dead docket, the state can ask for a null pros. Why do you need, I mean, what does this remedy do for the legal system?
Are you talking about the dismissal for want of prosecution,
Yeah.
Your Honor? It is important exactly for what happened here, which is you have a judge who is left with no alternative to move a case off of her docket.
No, they could have dead docketed, null prosed it, granted a continuance, or called the case for trial.
So you
Those
have
are four alternatives.
You have a judge who says, State, you didn't ask me for a continuance prior to it. The state never asked to move to null pros the case. They aren't giving the court any available alternative except for you must continue this case because we are outside the statute of limitations.
Call the case.
Say we're going to start right now.
That's what's reflected in the court's, the actual order that was commemorated in this case. Obviously, we don't have a transcript. The state did not file a transcript from the hearing that occurred there. We know that the judge called the case for trial and that the state announced that they were not ready to proceed.
All right, thank you, Mr. Sessions.
Thank you all.
Ms. Disman?
May it please the court, and for the final time, Mr. Chief Justice Melton. My name is Michelle Disman, here on behalf of the state of Georgia, the citizens of Cherokee County, and Solicitor General Todd Hayes. Asking this court to affirm the Court of Appeals and hold that a trial court cannot dismiss a case for want of prosecution after the statute of limitations, as such dismissals operate as impermissible dismissals with prejudice from which trial courts are prohibited. They impinge upon the separate and distinct roles necessary for our criminal justice system, and there are other procedures and remedies available to trial courts.
Can they dismiss it before the statute of limitations?
The creation of a dismissal for want of prosecution seems to originate from as far as back as I could chase it, from a 1978 case called Cooperman, in which they simply say that 9/11/41, the Civil Practice Act, does not apply to criminal cases.
Which they is they? The Court of Appeals or us?
The Cooperman case is
Court of Appeals.
a Court of Appeals case from 1978, and everything seems to tip off from the Cooperman case in 1978.
So assuming a judge has the authority to dismiss for want of prosecution prior to the statute of limitations but not subsequent to, what if it's dismissed the day before the statute runs and there's not another term of court for 2 weeks?
Well, what I would say to that is that to allow a dismissal for want of prosecution that prohibits the prosecution at all impinges upon the separate roles that this court has long held should be separate within. That impinges upon the neutrality of the trial court as well as the state's role to bring charges.
Why does that impinge upon the neutrality?
Because at this point, they've prohibited the prosecution of that case and terminated.
Doesn't the state have an obligation when it's time, when they're bringing a case, to bring forward their evidence and witnesses, or to face adverse consequences like a judgment of acquittal?
Well, the statute of limitations requires that we commence a prosecution within 2 years in a misdemeanor case, which there's no doubt in this case that we did. The case was transferred from Holly Springs Municipal Court. It was approximately 9 months old when we got it. At that point, we accused the case, I believe, within 30 days is what the record reflects on that, and we proceeded with that case.
If the trial court dismisses your indictment on a demurrer, is that the court being, partial because it kills the state's case?
Your Honor, in that case, the court would have a legal basis to do so because the charging document was factually defective and there was a constitutional violation.
Then your argument has to be that the court has no legal authority to dismiss a case for want of prosecution at all. Because once you say the court can do it, if the court does it under legal authority, how does that impair anything? Separation of powers, impartiality. I mean, courts apply the law all the time.
Certainly, Your Honor, and that's where we get back to the idea that this dismissal for want of prosecution idea is largely developed by dicta and not by statute at all. All of the other means in which a trial court would dismiss a case are somewhere in our statutes. The immunity, double jeopardy.
So is the state's position now that we should overrule all of the cases that acknowledge the trial court authority to dismiss for want of prosecution?
I think the better standard in this would be to allow the defendant to file a motion for a speedy trial demand.
So is that a yes, we should overrule all of those cases?
I think that we should and provide for a speedy trial demand as opposed to the dismissal for want of prosecution. That requires hearings, evidence. It puts the state on notice that this is what's going to happen.
We're not in the business of generally making new rules or fixing particular cases. We're in the business of trying to figure out what the law requires or prohibits. And so what we're trying to figure out here is what the trial court did, is that prohibited by law? And at least from the briefing, it seems like most of the argument the state has hinges on banks. We haven't even touched on that yet. But to Justice Peterson's question, we're not going to just point to something that could be done better, because we have to think about the rule in this case and all the cases that follow. So can you help us figure out what that authority is?
Sure. So the Banks case cites back to Grimes, Roca, and Luttrell. That's where they get this from. And the Grimes case comes out in 1990. The Roca case comes out shortly thereafter. They're all in the early 90s.
Did those cases do anything other than acknowledge that something had happened? I mean, did they just say that was not an abuse of discretion or that was not an error, or did they set forth legal rules?
So in Roca, they mention back to Grimes twice, and they actually, in the Roca decision, talk about, and it is at least mentioned in there, that it was within the court's consideration when they did this that the state could refile those charges. That's certainly discussed in both Grimes and Roca to that effect. And the Banks decision is largely a combination of cases both out of this court and out of the Court of Appeals, and applying those with those principles in mind. And if we take what this court has said in Berkey, which is the substance and the effect control over mere form and terminology, then what the...
So how far does that principle go? Because, I mean, in law, form matters a heck of a lot. There are lots of circumstances in which we say substance controls over form, especially in the context of, say, motions. If the title of a motion is one thing, but the relief that's actually sought is another thing, we'll say that the relief sought is what controls. But form in law matters quite a lot. And so why in this particular circumstance is it that the substance should control over the form?
Well, for a couple of reasons. One, Your Honor, when we consider the effect of it, the Berkey decision was about a trial judge that denied a motion for new trial and said on the general grounds. And they said, well, this court said that's acceptable because the general grounds as a matter of law are codified, and everybody understands what those general grounds are. And so the substance of that order saying I deny on the general grounds is sufficient. Here, what we have is an order that on its face is silent. What appellant would ask you to do is impute into that it was intended without prejudice and that trial courts are presumed to know the law under Price.
Why would we assume the opposite?
Well, if we take appellant's proposition that we assume that it's without prejudice and that trial courts are presumed to know the law, then that flies in the face of the Banks decision, which, while not controlling on this court, had come out 3 months prior to the dismissal for want of prosecution in this court's case, in which this trial court did not follow the holding in Banks, which is that you cannot dismiss for want of prosecution after the statute of limitations had run.
It seems a little formalistic, as it were, to argue about whether the four corners of a document was with prejudice or was without prejudice, because you can acknowledge that it was not with prejudice and still ask the separate question, was the trial court authorized to do that at all? That's a separate question of, was that done with prejudice? You don't have to show something was done with prejudice to say that the court wasn't authorized to do it. I think that might be a helpful paradigm to explore.
So I don't believe that the trial court was authorized to dismiss the case for want of prosecution at all. The state never announced that it would not proceed to trial.
Do you mean just in this case or in any case?
Well, certainly the facts of this case, the trial court was not authorized to dismiss for want of prosecution.
When you say the state announced that it never announced, how do we know that?
So there's no transcript in this case because this part of this wasn't taken down, to be candid with the court. What happens in this case is that the court calls through the regular calendar. The state says...
None of that's on the record, right?
It's not, Your Honor.
Okay, so why don't we talk about something that we can actually... I mean, I don't know what we do about that. If you tell us it's on the record, we can't... I mean, if you tell us it happened, we can't rely on it in an opinion, right?
So certainly, Your Honor. But the fact of the matter is that there was... The trial court never said, I'm calling the case for trial, call your first witness, which would attach jeopardy in this case.
Well, again, we don't know that. What we have in the record is the order, correct? leading up to that order, there's no transcript, correct? We have an order that's silent as to whether prejudice or not. Order doesn't even speak to statute of limitations, correct?
That's correct.
Can I ask, so do you acknowledge a rule that the trial court can dismiss without, for want of prosecution if it is without prejudice?
Well, I think that's a tricky question, Your Honor, and the reason that I say that is that it seems to be that this whole idea of a dismissal for want of prosecution is largely created in the dicta to begin with.
Let me ask this then, counsel, and I also want to circle back to Justice Boggs' question earlier. Within the statute of limitations, trial court puts the case down and calendar, state's not ready. We'll continue it for 60 days. Calendar, state's not ready. We'll continue it for 60 days. You can tell however many times you want to. Is there a time at which the trial court can say, I'm dismissing this case, the state is perpetually not ready, and you're wasting all of our time? Can the trial court do that?
There's no creation in statute to do that.
But is the state's position that a trial court can or can't do that?
I believe that there's other remedies available to the trial court.
I'm asking, though, does the state of Georgia have a position about whether a trial court can dismiss inside the statute of limitations or outside? Does the court have the power to dismiss a case without prejudice?
Or is it your position that one answer to that question is yes, case law says judges can do that, but a better answer might be that those cases are wrong, but we don't have to reach that conclusion to rule for you? Is that the position that you would take?
That's where I was headed, Justice Peterson, is that...
Well, let me give you a third one then. Or that it would be better left for the legislature to resolve this.
Well, you know, the legislature hasn't seen fit to create a statute saying that they can dismiss it for want of prosecution.
Are there any inherent authorities that a trial court has that could cover the situation?
Certainly the trial court has the authority to call its calendar, things of that nature, if that's what you're trying.
I mean, it sounds like Justice Bethel's scenario sounds a lot like calling a calendar and managing its courtroom, managing its docket.
Well, I want to circle back then to Justice Boggs' earlier question. If on two scenarios, if on the day this case was called, and again, we only just have the order. I understand you've got representations about what happened. If instead of entering a dismissal order, the court had said, I am calling the case, state, you're up, call a witness, and you had said, my officer's not here, I cannot prove guilt beyond a reasonable doubt without my officer, Your Honor, the state has to rest, and we got a judgment of acquittal. That can happen, right?
Absolutely.
Okay. So could the court, in my scenario that I gave you earlier, could the court in any one of those 60-day extensions have done the same thing and just said, no more extensions, call a witness?
They certainly could have called the case for trial on any date that it was obviously noticed for trial. But as Justice Namias pointed out during appellant's argument, just because our arresting officer wasn't available at the very minute that the court wanted to call the case for trial, there are 8 other witnesses listed on that accusation. We can certainly start a trial. This is a 2-car accident with the drivers of the other vehicles, the first responding officer, et cetera. There's no requirement that they all be sitting there waiting for trial.
Is that an argument that's really available to the state, though, when the state told the judge we're not prepared to go forward?
Well, the state announced not ready. The state didn't announce that they wouldn't proceed to trial.
The way the trial court order phrased it, it says the state announced that it was not ready to proceed. What should we make of that?
And that's really the only record we have of what the state said.
So I think that there's a difference between not ready to proceed and won't proceed. And while this seems like a minor detail, there's an important issue here between a dismissal for want of prosecution and the judgment of acquittal. Because essentially, when the trial court is issuing this dismissal of want of prosecution, it's determining, without hearing any evidence, that the state doesn't have a sufficient amount of evidence to prove its case.
Based on the state's representation. I mean, that's what the order says.
Well, the order said that it wasn't that it was not ready. That doesn't mean that we can't proceed.
What do we have in the record that demonstrates that notwithstanding the trial court saying I'm going to dismiss for want of prosecution based on the state announcing not ready, that the state was otherwise ready to call its second through eighth witnesses?
Well,
What do we have in the record?
unfortunately, not a lot because the court reporter wasn't in the room and I can't fix that.
Isn't it worse for the state to have the court call the case, the state can't proceed, and enter a judgment of acquittal? At that point, jeopardy's attached, right? And you're done. Whereas if the court dismisses with or without prejudice, the state has the opportunity to re-indict, at least some of the time.
Sometimes.
If we're going down the road of figuring out whether it's dismissal with prejudice, I mean, it's not just a statute of limitations, right? The state can't indict someone 3 times, right, if there are 2 bad indictments. So how does the judge says, okay, I'm going to dismiss for want of prosecution without prejudice. Does the judge have to inquire of every potential ground that might bar a re-indictment before the judge can enter the order? I mean, just in real world terms, has a judge figure out tolling, whether you've indicted a couple times already, you know, if there's some other thing out there that would prevent a re-indictment?
Well, I think in those circumstances, this is why a dismissal with prejudice is a shaky ground to begin with. If we took these same...
No, even a dismissal the court wants to be without prejudice. How does the court figure that out? Standing in the courtroom, you're in the courtroom, the state goes, we're not ready to go forward. The court says, I've called this case 7 times. You know, I'm dismissing for want of prosecution. It is without prejudice, I think. Tell me if
Obviously, that leads to a further inquiry, which is problematic with dismissals for want of prosecution generally. If we took these same facts and instituted them before or after the statute of limitations in the construct of the fact that the defendant had asserted a speedy trial demand, that would require a whole hearing to decide who's responsible for the delay, weigh it against Barker versus Wingo.
Counsel, I appreciate, this is the second time you sort of said the defendant should bear the burden of a speedy trial demand, and that puts the state on notice. But a trial court's trial calendar puts the state on notice that a case is going to trial, right?
It does put the state on notice that the case is going to trial, but it doesn't necessarily put the state couldn't have anticipated that this is what the trial court was going to do to bar the prosecution either.
Why could the state not anticipate that when the court has brought in all of its personnel, the defendant has marshaled its case and all of its witnesses, that the court could say, I am not happy with this? I mean, I understand the legal issue about that we're at, but why would the state not be able to anticipate that showing up unprepared, and I understand this is a witness is unavailable, but why would the state not be on notice that that's a problem?
But I guess my issue with it is that at the same time, there are, as a practical matter, when you're a prosecutor, there are so many moving parts as to whether or not witnesses can be available and things of that nature. And in this case, the court...
If you've checked with your witnesses for the cases that are on the trial docket and you know that somebody's on leave, and we keep saying we could have called 2 through 8, but the trial court's actual order says the arresting officer was not present and would not be appearing. So on leave, right? I mean, that was what was in the order. So if you know they're not there, you have the option of null processing. You get by your 6 months in that context, a motion for continuance that's there that allows the defense to say, well, you know, we think we're going to get a continuance because there's a full trial calendar. All those are available, right?
Well, in this case, we couldn't have null processed the case because it was outside the statute of limitations.
About putting it on the dead docket?
Well, all of this would require the court's consent. It would require the court's consent to null process the case. It would require the court's consent to dead docket the case. And the state was never given an opportunity to move for a continuance, a dead docket, or a null process in this case.
You say you were never given an opportunity. Was the trial calendar published on the day of the trial calendar being called?
I don't know the answer of when the trial calendar itself was.
Are they usually published on that day?
Usually we get a day or two ahead of time on those. Obviously not in the record, and so, you know, you can't really consider it, but the officer was at a funeral is really what the underlying issue here is. And what I would point the court to is that this is an extreme remedy that impinges upon the state's right and duty, as this
Although
court
it's
has
a
said.
less extreme remedy than calling it for trial and granting an acquittal for failure to present sufficient evidence, right?
In a certain sense, but in another sense, there's no hearings and very little procedure, and left entirely up to the trial court with hardly anything for the appellate courts to review if we allow these dismissals for want of prosecution.
What would you rely on for the proposition that in exercising the discretion of a trial court judge to enter a dismissal with or without prejudice, that the judge is required to hold a hearing?
Well, what I would point the court to is that other jurisdictions have looked at this issue. And what they have determined in this as recently as, in fact, actually, after I filed this brief, in Alabama, they issued an opinion called State v. Stallworth. It's 2021 Alabama. Can I finish?
You may finish that question.
Alabama Criminal Appeals, Lexus 26. It came out in 2021. They cite Georgia case law from the Court of Appeals in Aldridge and Carr, as well as case law from a number of states and the D.C. Circuit Court of Appeals, and hold that a trial court cannot dismiss a case for want of prosecution absent a constitutional violation that rises to the level of a speedy trial demand. I know I'm out of time, but I'd be happy to brief this issue for the court on this particular issue of the speedy trial demands.
I think we've got what we need, but we'll do our continued research on this. But thank you, Ms. Disman.
Thank you.
I believe both sides are out of time, so thank you all very much for your presentations, and we'll look forward to getting back with you.